The Supreme Court decision in Connolly dealt with life insurance in the context of redemption agreements. That is, where the life insurance is paid to the company so that the company can use those proceeds to buy and then retire shares of a deceased owner. There are a lot of companies in the US where redemption agreements are the primary way that business succession is structured, where buy-sells are structured that way. For those small businesses that aren't concerned with estate tax liability, this decision doesn't particularly matter. But the prior guidance from the IRS and Supreme Court prior to the Connolly decision was different. So the Connolly decision seems to be a significant change and indicator in the way the IRS is going to view situations like these moving forward. So any small business owner that has anywhere near a taxable estate needs to consider revisiting their buy-sell provisions and their life insurance, because 40% of those life insurance proceeds could ultimately be subject to estate tax, where there are other ways of doing it. Now, the Supreme Court specifically noted that the result would have been different if the owners had used what's called a cross-purchase agreement, where each of them owned policies on the other, the proceeds were paid to the other and not to the company. And in this particular case, if those proceeds had never been paid to the company, the value of the company never would have gone up. So cross-purchase agreements are a great solution for certain small business owners. The problem with cross-purchase agreements in the context of buy-sell is the more owners a company has, the more life insurance policies need to be purchased and maintained and administered. So between two owners, like in the Connolly case, it would have been a life insurance policy on each of them. Not really much of a problem. That's what they had already. But if they added just one more owner into the mix, then each of them would have to have a policy on the other two owners. So owner A needs a policy on B and C, and you can kind of do the car wash there and see that that turns into 6 life insurance policies with 3 owners. With 4 owners, the math gets a little more unwieldy, because now all 4 owners need to have 3 policies, so that means 12 life insurance policies. Hopefully you can see where I'm going with this. The more owners we have, the more difficult it is for cross-purchase agreements to be the ideal method to ensure buy-sell agreements. So redemption agreements in the context of buy-sell and life insurance are still a very straightforward and efficient way of doing business succession planning, but now we have estate tax considerations that maybe we didn't think of prior to the Connolly decision.